Great. Good morning. So my presentation here is to answer the question about what BC is doing about cannabis and other drug-affected driving. The Minister this morning highlighted some of the key changes, and I'm going to provide a little more detail on what those changes are. And but to answer the question about what BC is doing, I want to start by briefly outlining the province's immediate roadside prohibition, or IRP, program. And why do I want to start there? Well, because IRP is without a doubt where it is we want to go. Now, IRP was introduced in September 2010, and there were key aspects which led to the development of IRP, and two of them are that we had here in British Columbia a decade or more of no real progress in reducing the alcohol-related motor vehicle fatalities, and there was also a significant burden on the criminal justice system here. Approximately 30% of all provincial court cases were criminal impaired driving cases prior to IRP. So what is the IRP program? Well, one novel key component of the program is that it's an entirely administrative approach to addressing drinking and driving. And so police serve IRP sanctions at roadside, and when they do, no criminal impaired driving investigation then takes place. So IRP sanctions are served on the basis of the result of a driver's sample of breath that's measured at roadside by way of an approved screening device as shown here. Now, a driver who blows a so-called warn set out in the legislation is 50 milligrams to less than 80 milligrams of alcohol in 100 milliliters of blood is subject to the penalties that are listed here. Now, a driver who blows a so-called fail, which is set out in the legislation as 80 milligrams or more, or a driver who fails or refuses to provide a sample of breath is subject to the penalties here. Now, another key aspect of the IRP program is the administrative review process, by which I mean a driver who seeks to appeal their IRP prohibition. So any driver that's served with an IRP may, within 7 days of being served with it, apply to the Superintendent of Motor Vehicles for a review of the prohibition. Now, the specific grounds upon which the superintendent decides either to confirm or revoke the prohibition are set out clearly in the legislation. And the legislation also requires the superintendent deliver a review decision within 21 days of the person being served with an IRP. So it's a fair yet efficient means of a person getting a decision on appeal of their prohibition. So what's been the outcome of the IRP program? Well, right here is shown in blue. Since it was implemented in late 2010, there's been a 50% decrease in alcohol and motor vehicle fatalities in this province, and the estimate is that that translates to 351 lives saved since September 2010. And this graph here shows the impact on the court workload. So on the left side here, prior to the implementation of IRP, police were submitting to Crown Counsel about 700 to 800 reports for criminal impaired driving charges, and these are reports to Crown Counsel for approval of the charges. Once IRP was introduced, that number plummeted and went down to somewhere just slightly north of 100 reports to Crown Counsel per month. Now, that middle bulge there, we'll call it the Battle of the Bulge, if you like, that's when a 6-month period when the fail portion of the IRP legislation was suspended as a result of a BC Supreme Court decision. Legislative amendments were introduced, and as you can see to the right of that bulge there, the reports to Crown Counsel went back down. So IRP represents, I'm going to call it the promised land in this province when it comes to battling impaired driving. But the key question is BC implementing an IRP program for drug-affected driving? And the short answer to that question is no, at least not in the coming months. there are a number of challenges to introducing an IRP-like program for drug-affected driving, and I'm going to go through those in a few moments. But before I do that, I just want to show a few slides, some of which are going to echo some of the previous slides were shown earlier today. A few slides that sort of demonstrate or set the context of what we know and perhaps what we don't know about the problem of drugs and driving in this province. So this slide here shows the crash rate per 100,000 licensed drivers in BC based on an average between 2009 and 2015. And the crashes here are listed by contributing factors as reported by police who have attended the crashes. Now, as you can see, driver distraction accounts for the largest portion, followed by speed and then alcohol. Drugs are identified as a contributing factor in less than 1% of crashes per 100,000 licensed drivers, and that compares to about 5% of crashes where alcohol is identified as a contributing factor. Now this slide here shows motor vehicle fatalities where drugs and where alcohol were contributing factors between 2007 and 2016. Now, the blue line here at the top, that is where alcohol is identified as a contributing factor, and the red line below it is where drugs are identified as a contributing factor. And I think you can see at 2010 there's a significant decline in the motor vehicle fatalities where alcohol is identified as a contributing factor. And there's also a slight decline, interestingly, in those motor vehicle fatalities where drugs are identified as a contributing factor. But it's also interesting to note that around 2014, if you look at the red line below, there's a trending upwards in motor vehicle fatalities where drugs are involved. Now this slide here shows the number of drug-impaired driving incidents reported by police annually in BC, and that's the blue line at the top, as well as the number of reports to Crown Council seeking charge approval for drug-impaired driving, and that's the red line below. And while the number of drug-impaired incidents and reports to Crown Council are relatively small, I think in 2016 there was about 284 reports to Crown Council for drug-impaired driving in this province. You can see, as similar to the last slide, a trending upward in 2014. So Doug Berness showed earlier in his presentation some of the results of the roadside surveys. And this slide shows the results of surveys in 2008, 2010, and 2012 here in British Columbia. And the blue represents the portion of drivers where presence of a drug was detected, while red represents the proportion of drivers who tested positive for the presence of alcohol. And as you can see, in 2008 and in 2012, presence of a drug was more prevalent than presence of alcohol. And just to echo what was said this morning, the most commonly detected drugs, number one, was cannabis, or THC, followed by cocaine, and amphetamines, methamphetamines, and then opiates. So what tools do we have under provincial law right now here in British Columbia to address drug-affected driving? Well, there is one, which is in contrast to several different administrative approaches we have for alcohol-affected driving. And that tool is the 24-hour driving prohibition. And here in British Columbia, when police serve this prohibition, they also have discretion to impound the driver's vehicle for the same 24-hour period. Now, this prohibition has been in place for many decades, and it's going to remain, in the short term anyhow, an important tool to get drug drivers off the road immediately here in this province. Now this slide shows, which is interesting in contrast to some of the previous slides here, it shows the number of 24-hour prohibitions that have been served for drug-affected driving, and you can see a general downward trend here. And in 2016, there was about 2,600 24-hour prohibitions served. And so I think that downward trend here is interesting. As I said, it's an interesting contrast to some of the previous slides and raises a number of questions. So I mentioned earlier about an IRP-like approach, and there are some challenges. And so I'm just going to step through a few of them right now. But before I do that, I'm just going to say that we do believe it's possible to implement an IRP-like approach. But here are some of the challenges. First and foremost, When it comes to the detection and testing of drugged drivers, it's a different ballgame than it is with alcohol. We don't yet have a device that can be used at roadside to provide scientifically reliable evidence of a person's blood-drug concentration in the way that we do with alcohol. The standard field sobriety test and the drug recognition expert evaluations are very important tools delivered by extremely well-trained police officers in this province. But because they are based on subjective observations, an efficient yet fair IRP-like administrative review process that delivers a decision on an appeal review within 21 days will be very challenging if there is no corroborating objective evidence. Now, in terms of expenses, DRE training, I'm sure most of you are aware, is very costly. And also, DRE officers go on to do other things. More DREs need to be trained. As well, oral fluid screening technology is very expensive, and somewhere in the neighborhood, based on estimates that I've seen of the cost of these devices, about 400% to 500% more expensive than approved screening devices used for alcohol. And as well, each test is significantly more expensive than a test used on an approved screening device for alcohol. Now, some other considerations in considering an IRP-like approach is the scope and scale of the problem of drug driving. It's far less understood than it is for alcohol-impaired driving, and we've seen that as in some of the other presentations here this morning, the lack of data. More research is required. And finally, IRP was established after decades of case law, research, and advances in technology. And even then, there has been a large number of challenges to the constitutionality of the legislation. So, an important milestone here in constructing our approach to drug-affected driving was this province's public and stakeholder engagement process that concluded or wrapped up late last year. And British Columbia's had an opportunity to recommend to government what they thought should be done to address the problem of drugs and driving. And the top-ranked actions provided by telephone survey and online respondents were a public education and awareness campaign and zero tolerance for new drivers in the graduated licensing program. So, what is BC's approach? Well, what we're doing is adopting a cautious approach of phased implementation in which we'll be seeking to bring into force new laws in the coming months and then look at a second phase of changes at some point in the near future when we have confidence that some of those challenges that I highlighted earlier can be properly addressed. So in 2018-19, what we are going to do is put in place some of the foundational pieces that can be leveraged and support that second phase that we've got up there. So what's in the first phase? Well, as mentioned this morning, Bill 17, the Motor Vehicle Amendment Act, was just introduced this past sitting of the BC Legislature, received royal assent on May the 17th, and it includes essentially two new enforcement tools for police, and that is a zero tolerance for new drivers in the graduate licensing program in this province, and a 90-day administrative driving prohibition. So the zero tolerance for new drivers is a scheme that essentially mirrors what we have in place now for the presence of alcohol amongst the same class of drivers. So drivers will be subject to a roadside suspension, a violation ticket, a fine, and a further driving prohibition of between 1 to 6 months. And in addition, once the driver gets relicensed, the clock will reset on their participation in the graduated licensing program, meaning they stay in it for longer. Now, obviously, as the pictures here indicate, enforcement of the zero tolerance regime is going to require the approved drug screening equipment as authorized under Bill C-46 and is being tested now. So the other significant component here is the 90-day administrative driving prohibition. And this particular prohibition is intended in circumstances where police are seeking charge approval for a criminal drug-impaired operation offense. Now, the threshold for serving one of these prohibitions will be the criminal threshold, under the criminal code once Bill C-46 and the new drug-impaired offenses are in place. So we saw that in a previous presentation of Paul's, what those new offenses will be, including the combined blood drug concentration and blood alcohol concentration offense. So, for example, if a police officer believes as a result of analysis of a driver's blood that the driver operated a motor vehicle over the legal limit set at 5 nanograms of THC, then the officer may serve the prohibition on the driver. There's also grounds for an ADP to be served as a result of an evaluation of a drug recognition expert. However, what is important to note here is that the 90-day ADP cannot be served until confirmation of toxicology results are returned by the RCMP lab. Now, this ADP approach also includes an administrative review process similar to IRP, whereby a driver within 7 days of being served with the prohibition may appeal to the superintendent of motor vehicles, and the superintendent has 21 days from the time that the driver is served to conduct a hearing and render a decision unless that time is extended by the superintendent. So in terms of challenges, even the cautious approach that we're taking in phase one has a number of them. Clearly, the questions still remain about the status of Bill C-46. It hasn't yet been passed, and the drug screening equipment that will be used to enforce the zero tolerance scheme is still being tested. Another challenge is the delays and backlogs at the RCMP lab. We're now moving into a brave new world of blood drug concentrations. However, it can take months for police to receive blood samples back, and or the results of the blood samples. And if this delay is not addressed, not only will it take a substantial time before the 90-day ADPs will be served, but prosecutions of drug-impaired driving cases could be jeopardized in the post-Jordan world. There's also legal challenges. Impaired driving remains one of the most litigated areas of the law, and Bill C-46 represents probably the most significant overhaul to the impaired driving laws in this country in a generation. So you can bet that there's going to be a lot of new case law in the coming years, and that's going to impact all provincial and territorial administrative programs. Zero tolerance approaches across the country are also going to face challenges, too, from medical users of cannabis who are going to say that they are being unfairly sanctioned for having persistent levels of THC in their system. And another related challenge is going to be from those who claim, oh, I never smoke cannabis, but I just happen to spend time in a closet or other confined spaces with a lot of people who do. And so what this means is that the science behind whichever device or devices gets approved, no matter what the detection thresholds are set at, they're going to be rigorously examined by the courts. You can bet on that. But as we grapple with those types of challenges, as I just mentioned, we don't want to lose sight of the promised land. We believe that we can build a regime of escalating sanctions served at roadside based on a balance of subjective and objective evidence. And we also believe that such a regime, like our ARP, can provide a well-defined, fair, and yet efficient administrative review appeal process. But to get there, and to get there sooner rather than later, the right foundational pieces have to be in place. And we believe that phase one, as I've shown in here, provides the right foundational pieces, and it's what we'll be working to implement in the coming months. Thanks very much.